Are you're calling it Title Quest, Anita? Is that what I saw?
Yes, I changed the name. It's Title Trench now.
The title trenches.
Trenches. That sounds a lot more dangerous. But it's gonna be some danger, and there's gonna be some gifts and prizes worth, I told the people tens of dollars, so they're very excited. It's a tough market out there, so this is tens of dollars means a lot.
Thousands of pennies, that's for sure. I promise that.
All right, awesome. So Anita is the president and founder of The Closing City, and she's been with us before, and she is fantastic. So I'll let you take over, introduce Jennifer, and do your thing.
All right. Good morning, everyone.
Hello.
I'm Anita Malick, and with me is Jennifer Metzger. And I had the pleasure of speaking in front of you guys about 2-3 weeks ago, and thank you for having me on again. And I'm going to go ahead and share my screen now so you can see a little bit more.
All right. There we go.
Can everybody see the screen? Yes. Do you know how to see it where you can see them? No, right. Okay.
Yes. Everybody's giving you a thumbs up. We can see.
Okay, great. Okay. All right. Hold on one moment. Ryan, we're just trying to figure out, we're seeing the screen, but we want to see you guys as well. So we're just trying to figure out how to do that.
The 3 dots at the bottom gives you ways to change your layout.
Okay.
Oh, no. I'm ready to see the Teams one.
The 3 dots at the bottom by where that has the phone for looks.
Oh, 1 second.
Hold on 1 sec.
When you don't accomplish your dreams and what you want, lo malo se te regresa.
Yeah.
Somebody's meditating.
Okay, I think that
Perfect.
Do it.
Okay.
All right. Let's see.
Or spotlight. There we go. Okay. Sorry. Well, that's cool. All right. Back to our PowerPoint. The title trenches.
Awesome.
All right, guys. So today I wanted to go ahead and introduce myself as well. So my name is Anita Malick, and I have been doing title, and I'm sorry if you guys heard this 2-3 weeks ago, but I've been doing title for about 14 years. I'm from up north, from Chicago, where I'm an attorney by trade, and I've represented buyers and sellers for several years. And in Florida, I operate The Closing City. We are the fastest growing title company in Florida. Got all the awards from our underwriters, and we're very proud of that. And we are hoping to work with you all, and just wanted to, my job here at the title company is I'm the issue spotter. So when things get complex, I jump in, I help answer questions. And like I said, I've been doing this for so many years. I understand the emotions that go behind closings. I understand what you guys go through. I understand problems that come up during the transaction at the closing table. So we've built this real estate platform called The Closing City to give everybody this sense of belonging, a sense of platform, a sense of place where you can tap into education, knowledge, and have smooth transactions. All our closers have 15 plus years of title experience. I don't have processors. I have one closer, one transaction, and very proud of my amazing staff. So that's a little bit about me. That's me right there. I don't practice law in Florida, so I don't represent anyone, but at the title company, we do have in-house counsel here. So if you're ever in a situation where you feel like you need an attorney, we're one-stop shop. We do it all. We do residential, we do commercial, our biggest client right now is Orange County, so we do all their closings, and we do a lot of investor closings. So that's a little bit about us. I have my co-host here with me today who will introduce herself.
Hello, everyone. I am Jennifer Metzger, and I am the relationship coordinator over here at The Closing City. I also do a lot of our signings when I can kind of jump in and get out to you when you've got clients maybe that aren't here and you're like, hey, listen, can we have something a little extra special? We need some champagne. So I'll be your deliverer for that. But basically, I mean, my goal is just to streamline everything. It's to enhance the client experience. So this way your customers walk away from this happy and want to use both you and us again, right, in the future. And that's really what I'm here for. But I would say our most important other host here is Huey the House. For those of you that haven't met Huey the House, he is our mascot at the Clothing City. He's a certified breakdancer, America's Next Top Model winner actually of this year. And he's single and ready to mingle. I'm just going to stop showing my screen here for a second so that you can see Huey the House right here. There he is. That's his joy. He's here all the time. This is all week. Anytime you need him for a closing, that's Huey the House. So,
and if you're signing at one of our offices, he makes an appearance quite a bit. Once again, he is single, so
if you know any other mascots that are looking, let us know. So anyway, back to the PowerPoint here. So, yep, that's Huey. Thank you, Huey. You did great.
So today, I just wanted to take, instead of last time, we talked a little bit about seller financing, and we went over, what to do when you're in that situation. Today, I wanted to actually do a title trench trivia. So this way we can make it a little bit more engaging. We could all share stories, and of course, walk away winning prizes. And this trivia, I have several versions of this, but today's trivia is 7 questions, and it's basically things that we see at a title company that go wrong, that either kill the deal or delay the deal. And these aren't necessarily title problems. They're not something that's coming up on our commitment or any type of liens or judgments. These are more communication, clerical types of things that we see when we get a contract and once the transaction starts. And we wanted to share what these are with you because it tremendously helps us and gives us all a stronger footing if we have that communication on par. And we want to make sure you avoid being a part of these trenches. So Jennifer will explain the rules.
Welcome to Title Trenches Trivia. These are the rules. We've got 7 questions. The first person to answer correctly with reasoning wins a $15 gift card. Raise your hand if you know the answer, or if you even just want to quickly pop up and just say, your name, we'll call on you. A maximum is 1 gift card per player. So if you do answer one correctly, give the next one to somebody else. Is everybody ready?
I think we need to change it where you can see the layout again.
All right.
Hey guys, there's a hand raise mechanism at the bottom. You should probably use that. It keeps them in order.
Okay.
Of who raised first. So those of you out there playing, you see the hand at the bottom, the open hand at the bottom of the screen. There you go. Daryl just did it. Unless you actually have a question, Daryl. He's just showing off that he could do it. All right, so Daryl's button is working.
Thank you, Daryl. All right. So
he's just cheating and trying to be the first one to guess at the first answer.
All right.
I'm lowering his hand. All right.
All right.
But hopefully everybody knows how to do that.
All right. So then we've got the first question. Let's get started. All right. So what's in a name? Sally purchased a home in 2017. The grantee name on the deed reads Sally M. Morse. In 2021, Sally married her best friend and changed her legal name and driver's license to Sally Morse Johnson. It is present day, and she's contracted with you to list the house. How should Sally's name read as seller on the contract, and why?
Can you see the hand?
It appears in the driver license.
And why would you say that?
Because that's the legal name.
All right, let's display the answer.
The best answer is to use Sally's current legal name as it appears in her ID. The contract is a snapshot of the party's current status and intent. So Sally will deed out the property using her current legal name, Sally Morse Johnson, formerly known as Sally M. Morse. Using the current legal name also notifies us, the title company, that her name has changed from the vesting on the deed and will help prepare accordingly.
And guys, this is something we see all the time. Where we get the contract, and often, I'm sure you guys are trained and briefed that when you do contract with someone, your job in the beginning is to information gather, right? So obviously one of the first things you want to find out are you go look up the deed and see who it's vested in currently, right? So if two people own the property, you want to make sure the same two people are signing the listing agreement and are the sellers as well. But you want to take this one step further and make sure that you do use their ID to capture the proper legal name. And that's the name, the one that's on the identification. That's the one you want to use as a seller on the contract. And the reason why it shouldn't be the opposite is because when you use the current name, first of all, that contract's a snapshot of the contract, right? And second of all, you also want to make sure that it will notify the title company. So once I get a title commitment back and I'm reviewing it and I see, okay, this says Sally M. Morse, but the contract has Sally Morse Johnson. Now I know that I need to collect a name affidavit and I'll prepare all my documents correctly. One of the flaws we see is sometimes at the last minute at the closing table, they'll come in and they'll provide their ID and we're like, uh-oh, this does not match what's on the deed. But like most good title companies, we do collect this information at the beginning of a transaction. We will attempt to collect it, but not always will we get the copies of the IDs or the right names. So the more we can learn to gather that information, that's the name you want to use. Anyone want to share a story of something that worked, didn't work, perhaps? No, we're looking good.
All right, so then moving on to the next question. But before I do, so I know that you just answered this one. If you could please, in the chat, once you answer a question correctly, just give us your first name and your phone number and your email, first and last name in the chat. So this way I can make sure I email you or text you the gift card. That would be awesome. All right, so next up we have trench topic number 2, powerless POA. Myrtle, a happy widow from Florida, has retired and moved to a wonderful 55-plus community in Scottsdale, Arizona. Myrtle loves to travel abroad to tour beaches in other countries. She is listing her house in Leesburg, Florida, and has asked you to represent her. She notified you that she has an executed power of attorney that grants her son, Jason, a Florida resident, the authority to act as her agent. Oh, Miguel, do you already know the answer?
Well, we'll finish reading it.
All right. The POA was validly executed in Arizona and correctly complies with the Arizona requirements of one witness and notary. Is this POA acceptable for Jason to consummate the sale of the Florida property on her behalf?
Miguel wants that $15 Starbucks gift card. Come on, Miguel, tell us the answer.
You're muted, Miguel. All right.
Well,
anyone else?
Anyone else? He took his hand down. So anyone else? Daryl Hunt.
So,
all right, Daryl, what's the answer?
I would assume that it would need to be a Florida POA because the property is located in Florida. I wouldn't think an Arizona POA would apply to a Florida property.
So Daryl, you're not fully correct. You're partially correct. Anyone else want to take a stab at the best answer? I'm looking for the best answer.
Miguel says it's a non-durable POA or not a durable POA.
Let's say for argument's sake, it is a durable POA. It's properly, validly executed. It does give son Jason the authority to sell, the home. Let's take it one step further. Maybe the POA even says that he has the right to sell. But there's one thing missing in here, in these facts that wouldn't work out. Anyone else want to take a stab?
Okay.
All right. So Daryl, you'll still be the winner, but here's the answer. This POA is not acceptable for Jason to consummate. Why? So you can use a POA from another state. That's very common, and that's perfectly fine. There's 2 requirements that we look for. The first requirement was the POA validly executed? whether it was in Arizona, whether it was in whatever state. And number two, this is the second prong that has to be fulfilled. Was it validly executed with Florida's execution requirement? Does anyone know what Florida's execution requirement is? It's the same as a warranty deed. How many witnesses do we need? Two witnesses, and we need one notary. So it could be an Arizona POA, but if it doesn't have the 2 witnesses that Florida requires, we can't accept that POA. Even though the POA is perfectly valid in Arizona, it just wouldn't be acceptable in Florida. So when you are representing buyers or sellers that need POAs, and if they're in a different state, they will ask you, can I use a POA? So the first thing, always reach out to the title company and say, hey guys, I'm about to list a property, or I have a buyer that's not going to be available for the signing and there's a loan involved, whatever the case is. First step, always ask the appropriate parties, can a POA be accepted? And second, if they haven't done the POA yet, advise them to make sure that POA has the 2 witnesses and the notary, because that's what we will need in Florida. And guys, often I do have agents that will reach out to me and they'll share a POA. And heck, if we're doing the closing, I'll draft the POA. I have no problem with that. So often we're drafting POAs. As long as we're doing the closing, I can certainly do that. And we can use that POA and make sure that that's what they execute. So just make sure the POA has power. It could be a good POA, but it may not have power in Florida. So Daryl, that was a great answer. It was just missing the witness part, but you are still the winner. Any other stories that anybody wants to share or experiences they had with power of attorney? No?
All right.
All right.
Dear Mr. President, in the history of the United States, only one president has mentioned the word title insurance during the State of the Union address. Which president was that?
It was shocking that a president said those 2 words. Never in the history. Most presidents don't know what title insurance is.
Anybody want to take a stab? Oh, Miguel Clinton.
Not Clinton. Luigi, do you want to take a stab?
You can't just, Miguel, you can't just guess every president.
I see a couple hands raised.
It is
Luigi?
smart though to pick the ones who did 8 years. That's I like that. That's 8 addresses, State of the Unions they gave. Okay, let's go, Luigi. I don't know. First one with your hand up. You're on mute if you have a guess, or you can put it in chat. I think you guys gave a pretty good clue. Is there a guess there? I'm going to have to go to Natalie unless you speak up. You're first on the list, Luigi.
No,
The second push.
No,
No.
not George W.
Anwar.
Hello, you hear
Yes.
me?
Hi.
Yes.
Yes.
Yes, I think it's Joe Biden. One time he talked about that. I'm not sure. I think.
Yeah.
Anno,
There you go.
you are the winner. That is correct.
Okay, good.
Good job.
It was
President
just a
Joe
guess. I wasn't sure about it.
on the dreary evening of March 7, 2024, uttered the words title insurance. And I can tell you, as I was not paying attention, doing something, looked up and said, what? Somebody knows what that is? So that it was Joe Biden who mentioned it. Unfortunately, the context was not very pleasing. He suggested a pilot program which would scrap title insurance on federally backed mortgages, leaving homeowners exposed to risk. Thankfully, the pilot never came into fruition during the administration, because I think one thing I will back up again and again and again is the importance of title insurance and understanding what it does, and leaving any homeowner without title insurance will put them in major exposure. And guys, we've worked with claims, played out claims, and it's probably one of the most important things you want to teach your buyers and sellers, what it is and what it does. So congratulations, Anna, you won that round.
Thank you.
Put your name, email, and phone number in chat. But all right, next one.
Topic number 4. Don't furp to me. Theo Almeida resides in Brazil and is selling an investment home in Claremont, Florida. The house is listed for $289,000. Since Theo is a foreign resident, he would be subject to a 15% withholding of gross proceedings submitted to the IRS. Theo asks if it's possible to avoid withholding the 15%. What is the best suggestion you and the tax professional will most likely give to Theo?
There you go.
Miguel.
Miguel, would you like to take a stab at it?
He's probably writing it in chat. I don't think his microphone's working.
Pay or reinvest.
Okay. All right. Anyone else have a different answer? So
No.
you're the agent, you're the listing agent, and Theo does not want to pay that 15%. He's saying, guys, I could really use that money to reinvest or do something else. Is there any way I can avoid it? Maybe the answer is no. Maybe the answer is yes. But I'm looking for the best answer.
Natalie put 1031 exchange.
1031.
You guys know this. You guys should know this. If not, I'm going to guess.
Go ahead, Ryan.
$300,000 and the buyers are going to live there full time, or it's going to be their primary residence. Can't they avoid FERPTA?
You are the winner of a $15 Starbucks card. That's the correct answer. So here's the thing about FERPTA. Every transaction is FERPTA. Okay, so that's the first thing. Every transaction is FERPTA. There are few exceptions to FERPTA. The biggest exception to FERPTA, which is used in 95% of all the sales, is called a non-foreign certificate. It's a certificate that the seller signs at closing that says, I'm not a foreign resident. I live in the US and I have a taxpayer identification number. So that's what we use for most of our sales. Now, then there's the other 5% where the seller does not live in the US. It's an individual and does not live in the US. That's your first cue. Okay, well, you're applicable to FERPTA unless there's an exception. In this certain scenario, there is an exception. And the exception that the IRS has laid out in their code is if the purchase price or the realized value is $300,000 or less, if the buyer signs an affidavit saying that this will be their primary residence and they or their family intend to reside in this house for 50% of the time over the next 2 years, then this seller doesn't have to submit the 15% FERPTA at closing. Doesn't mean that they're not responsible for capital gains taxes in the future, but at the closing time, they don't have to submit the 15%. So if you're in this situation where Theo is telling you, hey, I really don't want to pay this 15%, what are you going to do? We're going to go find a buyer or offers where the buyer is willing to sign that affidavit. Okay, so that's something you may actively have to look for. As you're considering offers, you may have to look for, that may be a question that you ask the other agent or the buyer that, will this be your primary home? Do you intend to live there for the 2 years? And a key thing, will you sign an affidavit, affirming that? Because folks, a lot of times what I see is people will get to numbers 1 and 2, but when it comes to number 3, they totally miss that step. And as we're getting closer to the closing, we reach out and say, hey, buyer, here's the intent to reside affidavit. And the buyer says, no, I don't want to sign this. I don't feel comfortable signing it. I'm not going to sign it. And now the seller has to submit that 15% or the transaction has to be canceled. So my suggestion is if you're in this situation, look for a buyer who will not only sign it, but have them sign it at the time of them signing the contract. And heck, even put in additional terms that an intent to reside affidavit has been signed by buyer. That way there's no ambiguities, there's no disconnect there, and we know that that buyer has already signed this affidavit and that 15% would not be submitted at closing. Anne has a question?
Yes, what if the buyer doesn't know and decide that after the debit, what happens?
What if the buyer doesn't know about it?
Yeah, then decide that addendum, but without really understand.
Yep. And that's a great question, Anne. And that's why on the flip side, if you're representing buyers, same thing. If your buyer is asked to sign this, this is something you or an attorney would have to explain to them. In the US, when there is a foreign seller, okay, and when this withholding has to be paid. Answer this question. Who is responsible for paying it? Who is responsible for making sure it gets paid? Anyone know? Is it the buyer or the seller? So the answer is the buyer, okay, which seems very, interesting. But the reason the buyer is responsible for making sure the withholding gets paid is because, think about it, the seller is foreign. IRS is not going to go hunt the seller down. They're not going to be able to find that. So who do they put the burden on? They put it on the buyer. They say, buyer, if you're purchasing a property from a foreign seller, you, buyer, are responsible for making sure that withholding gets submitted or an exception applies, okay? Now, the withholding amount is still paid by the seller, but the buyer is responsible for making sure that it gets submitted. And going back to your question, that if your buyer is presented with this affidavit, I have some buyers that won't sign it. They'll review it and they don't feel comfortable signing it because maybe they don't intend to reside in the house for 2 years. And their number one question is, what if I decide to sell after a year? Then what happens? Will IRS come after me for this 15% because, it didn't get paid at closing? And that's definitely, certainly a gray area. In reality, I haven't seen that happen much because, it is an intent to reside. So if the intent is there at the time that you're signing it, I think you're fairly safe unless there was some foul play, unless you meant to purchase it and then, turn it in an investment right away. And I would definitely make sure that the buyer understands what they're signing, because they really truly have to make sure it's their primary residence, and then they have the intent to reside there for 50% of the time over the 2 years. If the answer is yes, then I would advise the buyer, as they feel strong enough, to go ahead and sign it. If they don't feel comfortable, that's something you want to let the listing side know right away, because once again, you can see this could delay the closing or it could kill the deal.
In the past, I think I did not understand enough, and my buyers still don't understand enough. And I believe the title will not really explain that to us. And I think my buyers sign it. So.
Yeah, I get a good amount of buyers that just don't want to sign it, and then, and sometimes, this question has to come up during the negotiation phase. It shouldn't come up once a contract is signed, because you can see it falling apart, right? But during the contract phase where the contract is being drafted, this is when both the parties will have to decide whether this will be signed or not. And if the buyer doesn't want to sign, then the seller can move on to another offer. Or if the buyer really wants the home and it's going to be their primary home, they should sign it. But yeah, it's something that should be talked about. And if you guys need more, education on this, feel free to call me. Ryan, I'm going to open it out to the team that if you guys ever feel like your buyer or seller need explanation, I'm always happy to get on the phone with them. Like I said, I can't provide legal advice, but I could answer what the statute says, what the IRS code says, and what that affidavit says. And I can send you guys a copy of the affidavit we use so you know what it looks like.
Awesome.
All right, on to topic number 5. Entities and signatories. Bob and Billy, the best goat farmers Marion County has seen, team up to operate a farm. They create Goat LLC, a limited liability company with the operating agreement stating they both have 50-50 ownership. The operating agreement also says that Bob is the manager and responsible for day-to-day farm activities. Bob is also listed as the manager on Sunbiz. After 30 years of successful milk and cheese production, they decide to sell the farmland. Bob and Billy retain you as their listing agent. Who should sign the listing agreement and contract, and why?
So Anna, you've already won one gift card.
I think they are both of them responsible to be in the name of the listing agreement, so they both have to sign the contract because their both name is on the LLC partnership.
Yes. Does anyone else want to take a different answer?
Can you hear me here?
Yes, Miguel.
Thank you. I finally figured out how to work the microphone. It's a new computer. I went to something similar. Under the LLC, there should be an operating agreement on who is the assigned person for any transactions under the LLC. So it would be whoever would be assigned under that agreement under the LLC. Am I correct?
Yeah, and Miguel, one step further. So if you look at the facts of my question, it doesn't say all we have are these facts, okay? All we know is that they have 50-50 ownership, and all we know is that the operating agreement says Bob is the manager day-to-day, he's on Sunbiz, but the operating agreement is silent on major decisions. Is your answer still the same?
That is correct, because I went through this with a closing, and the the title company insisted that we make sure that the operating agreement under the LLC was very clear, and I had to redact it almost 3 times until it was accepted.
That's a great answer, and it's actually the correct answer. You're absolutely right. So, and I can't tell you how many times closings get delayed because of this issue. A lot of times, you know, a seller or a buyer will be an LLC, a corporation, a trust, and we have to make sure the right people are signing. And you, especially you guys, want to make sure, because your signing starts way before the contract, right? You have the BBCA or the listing agreement. So you need to make sure the right people are signing those documents, and it's not wrong from the start. So and so this goes back to the information gathering. So when you're with your client, it's perfectly acceptable to ask, you know, hey, who are the signatories of your LLC? Do you have an operating agreement? And feel free to send the operating agreement to the title company in advance. If you're not sure, we're happy to underwrite it, look it through, and tell you who needs to sign this, you know? And in this scenario, if it's silent as to who's making the major decisions, you're absolutely correct, Miguel. Both need to sign, because even though Bob is the manager, you know, even though you can go on Sunbiz and see, okay, Bob is the manager, that doesn't mean anything. Doesn't mean that Bob has the authority to sell the property. So therefore, in this situation, both need to sign it. Even if the operating agreement is unclear, when ambiguous, be on the safe side and say both need to sign it. So both should be signing your BBCAs, both should be signing this listing agreement, both should be signing the contract, and then both should be signing the closing documents. Now, keep in mind that they could do a resolution amongst themselves, and that resolution, you know, let's say Billy's not available, you know, and Billy and Bob sign a resolution agreeing that Bob would sign all the closing documents, the listing agreement, etc. That's perfectly fine. We could take that resolution and record it with the deed, or have it in our files. But until they don't sign such a resolution, both would have to sign it. Especially with LLCs, sometimes you'll come across like 6 different members, and you're just like, do all 6 need to sign? And the answer lies in the operating agreement. If the operating agreement says that all members need to sign, yes, all 6 of them need to sign every document unless they have a resolution or an addendum to the operating agreement stating otherwise. This is one of the biggest delays that we see. Often we don't get the operating agreement until we're well into the transaction, you know, and sometimes, you know, we have to chase the seller or the buyer for their entity documents. And that's when we find out, okay, wait a minute, these are the people that need to sign. So if you can gather that information up front, that definitely helps save time and making sure the accurate people are signing. Any other questions or stories on this one?
I just wanted to add, yeah, I mean, you really made it very clear. Anytime you have an LLC as a buyer or seller, the first thing should be an operating agreement, because most of the times they don't have one. My situation, exactly, it caused a delay. The client wasn't available. There was in another state. There were 3 people, and it has to be very clear. And that last point that you made, if no one is clear, somebody in the document, it should be made that if none of them is clear, this person is assigned an alternate or whatever. But it did cause a lot of angst, and also running around trying to get an operating agreement done. I have experience doing them, but some people don't and have to go ahead and hire an attorney or somebody to even do it, which can also become costlier, and it could really mess up the whole deal right off the bat. So the first thing that should be put on there, operating agreement, and then have them move forward. Thank you. I just wanted to reiterate that it was kind of really difficult for us to go through this thing, and it really put a damper on everything.
Yeah, it really does. And you know, another thing I always see is, you know, going back to DocuSign, because nowadays DocuSign is used to sign, the contract, etc. So if you are making the DocuSign, just make sure where it says seller signature or buyer signature, if it's an LLC or any entity, you want to make sure a natural person is signing it. So a lot of times I'll get the contract and it'll be, Go LLC, and in the signature line on page 13 it'll say Go LLC signed, and that's actually not a valid contract, and it could, if one of the parties wanted to terminate or make it null and void based on that reasoning, they could. And I've seen it happen, guys. I've been doing this for 14 years. I've seen all kinds of stuff. I've seen people get out of contracts because a natural person didn't sign that contract. So make sure in our scenario, Bob, dash or comma member, Billy, comma member. Make sure natural people are signing the contract.
All right. Moving on, we have trend topic number 6, property tax proration. Buyer Bob is purchasing a new construction home with cash for $450,000 in Davenport, Florida. The construction was substantially completed around March 19th, 2025, and a certificate of completion was also issued on that date. The closing is set for March 31st of the same year. The title company is calculating the 2025 tax proration for the settlement statement. The 2024 property tax bill was $540 based on its vacant land, but the estimated tax bill for a $450,000 purchase price would be closer to $6,400 per the tax estimator calculator on the county's website. The contract's tax proration clause says to use the assessment of the current year. If the assessment of the current year is not available, prorate based on last ascertainable taxes with current mileage. Should the title company prorate 2025 taxes based on $540 or $6,400 if the current assessment is not available?
So this is a handful, lots of information here, but it goes back to the new construction scenario where a buyer is purchasing a new construction. It was vacant land. Now a property is built. What should the seller give for tax proration? Should it be based on the vacant land or should it be based on the built price for that specific year? So that's sort of where this question is stemming from. I see Miguel and Anna have raised your hands, but you're only eligible for one gift card. So is there anybody else that wants a $15 Starbucks gift card that would like to attempt this question?
I don't want to point out the obvious, but you got a 50-50 shot. Natalie, she's up.
$6,400, Natalie?
All right. Since it's a 50-50, Natalie, you will be the winner, but the answer is wrong.
Oh, no, Natalie.
But you did great. This was a tricky one because, so the one rule you want to remember, here's the rule of the thumb, the golden rule. The rule is in all the counties in Florida, when the assessor assesses the value, the just value of a property, they use one magic date. Does anybody know what date through the year that they use? It's in my answer, I realize. But it's January 1st. So the magic question is, what is the just value of the property as of January 1st of the taxing year? So if you look at our scenario, the house was substantially completed in March, right? So in January 1st of 2025, it was not substantially completed. We're still treating it as vacant land. So that's really what the tax bill, when it comes out later in October, November, it should be based still on vacant land because the house wasn't substantially completed. Because of those facts, the fact that the assessment is not out yet, we would use the 540. Now remember, the contract governs this language. There's no law out there that says how should the proration happen, right? We always have to look at the contract. What does it say how to prorate? That's why I gave you some fact scenario. If the contract stated that, we would use the 540 unless the parties negotiated or agreed to otherwise. This is a tricky one. Any comments?
No, it makes sense though, because when the builder owned it, it wasn't worth anything. I mean, it was just a vacant lot. And then now that you own it, you'll owe taxes from April to December.
Exactly. Now, if we change this fact pattern and if the developer got the certificate of occupation in December of 2024, then when January 1, 2025 rolled around, it's a completed property, right? At that time, yes, we're going to use the $6,400 to prorate. That's the difference.
I would have guessed the same thing, Natalie.
Well, congratulations, Natalie. All
Thank
right,
you for playing, Natalie.
we're on to our last question.
All right. Trench topic number 7. Are we married? Hawkim is engaged to Sarah. They are purchasing a house together in Port Charlotte, Florida, and will be getting a conventional loan from a bank. You are their agent and have found them the perfect house. Their offer is accepted. 5 days before the closing, you find out that Hawkim forgot to tell you that he was married to Barbara, but not to worry because they've been separated for 2 years and will file for a divorce later when they have time. Can Hawkim and Sarah still purchase?
Has anyone been in this situation?
Yes. Have you been engaged and married?
Let's go with Fawn.
All right, I
Okay.
see.
Yes, I think they can still purchase this house because there's no law saying that non-married people cannot purchase something to real estate together.
Yes, that's correct. There's a little bit more to it, but so they can still purchase. All right. Now we've got a little bit of a situation, and this happens so often. You would
So
be
often.
surprised. So, we as a title company, we also gather information once a contract is in place, right? We'll send a buyer information sheet. We'll send a seller information sheet. The buyer information will clearly say, what's your marital status, but in Florida, you're either married or you're not. So there's no such thing as separated, right? Legally. So in this case, Hawkim is still married and he's purchasing a property that has a loan on it, so, and this happens so often. So in this case, this is what we would do, right? Worry not, we always have a solution. So we're always going to think calm-headed and we're going to say, all right, let's sit down. Let's figure out Hawkim, Sarah, and Barbara's situation. So it's still possible for Hawkim and Sarah to purchase, but we would first have to connect with Barbara, right? And Barbara would have to be on board with this. That would be the magic question, because Barbara will either have to sign a non-homestead affidavit confirming that this won't be her property, her homestead property, or she has to sign the mortgage acknowledging it. And the reason Barbara needs to be involved is because Florida is a homestead state. Mm-hmm. And when you are married, there are certain protection that spouses have, especially when it comes to homestead property. So if this property were to be homestead, for whatever reason, Barbara could come out of the woodworks, a year or two down the road and say, hey, what are you talking about? I have a third interest in this property because I was married to Hawkim when he purchased this. And by the way, he purchased it with my marital money. So those things could come up after the fact. So we want to, any lender will want to make sure that Barbara has blessed this purchase, either by saying it's not my non-homestead affidavit, I bless the both of them to go ahead and purchase it, or by acknowledging the mortgage. The more common solution you probably see is the spouse does sign off on the mortgage. It's up to the lender which one they'll accept. So we can still make it happen as long as Barbara is willing to cooperate. I've been in situations where I've had to call the Barbara and say, hey, Barbara, this is what's going on. And the agent and I would both get on the phone and see if she's agreeable. And if Barbara is, all right, I'm sending a notary to you, hang in there, and we'll get her to sign. But it's possible. It's just, once again, this goes back to information gathering. You want to make sure, you clearly ask your client, are you married? Are you still married? And that way we can avoid some of these things. Monica, I see you have a question.
Yes. So I'm sorry. I want to know, what does acknowledging mortgage means? Does that mean that she's becoming a guarantor? Like, what does it mean?
Yeah, that's an excellent question. So when the spouse acknowledges the mortgage, does not mean that they are the guarantor. Okay. The borrower is still the husband. The borrower will be the one on the note. The borrower is the one who's responsible for the payment. And if there is ever a default, the borrower husband is responsible for the default. That wife is not a guarantor. She's just acknowledging the mortgage. And so if he does stop paying, they won't come after her. Now, she will be listed on the foreclosure because she still has a vesting in the property, but any default judgment will not be against her. She's simply acknowledging it, that I'm waiving my homestead rights, basically, on this house.
Understood. Thank you.
Now, guys, this happens more often with just a regular married couple who one of them buys an investment property in just their name to flip it or do whatever. That's more common, right? As opposed to buying something with getting engaged again and doing something else. So anytime you have a married person buying something on their own, their spouse is going to have to sign if there's a loan involved. Is that
Yeah.
Yeah. Okay.
Yeah, that's and it depends on the lender's requirement. If it's their primary home, if it's that person's primary home, then most of the time the spouse has to sign. If in that loan application the husband doesn't mark it as a primary home, then most lenders actually don't need the spouse's signature, as long as it's a second home or investment home. So most lenders won't need it. But if it's a primary home, then yes, they will want the spouse's signature.
Okay, fantastic.
Well, that was our last question. Jennifer, can you go over the winners? I'm not sure if we have the winner for question number 1. I'm not sure if we got her name.
No, you didn't. I'll give it to you. She texted me on the side.
Okay. Okay. And then I think
Daryl, I believe Daryl, you won question number
2.
2. And then question number 3 was Anno. And then I don't think anyone.
I won one. And I'm going to give mine away.
Ryan won question number 4. And then we had Miguel for 5. 6 was Natalie, and then 7 was Fawn.
Yes, if
Perfect.
you haven't shared your email, phone number, name, please share it. We'll email you your digital gift card. Thank you for playing. We wanted to make this engaging. We wanted to make this for you to share any stories that you've been through. These are just trenches that we see from a title company standard day in and day out. And communicating these things can definitely save your deal, make it work smoother and faster. And I always say this to everybody. I'm always here. My job is to be an issue spotter. So I know after the last call, that I came here 2-3 weeks ago, a couple of you did reach out to me with questions, and I'm happy to always be here and answer. And that's really what I'm here for. So if you're confused about something, feel free to call me. I'm happy to explain it. Or if I don't know, I'll direct you to the right place. And that's us at Pleasant City. We hope you enjoyed playing this, and hopefully we'll see you next time if anyone doesn't have any questions.
For more title trivia.
Anita, I want to do something while you guys are still here. All right, to everybody out there, for my gift card, $15. What do you need a buyer brokerage agreement if you are if you are buying a house yourself? Do you need a buyer brokerage agreement if it's for yourself? Anybody? And or you can win mine.
I think they still need it. Even
You
if
do. You
Yes.
do. You get it. And you know what? Jika owes you another $15 because he got it wrong in the chat.
No.
So I'm kidding, Jika. You don't. But you can have mine. So give Anno Anwar mine, please, as well.
Thank you.
Yes, you got it right. I get that question all the time, guys. Or you guys try to say that you don't need one when you turn in your paperwork. You still need one. So that's just my little pet peeve of the day. So you can have my gift card.
Awesome. All right, I will send all of those out to you guys today. So let me know if you have any issues with that, and I will put my contact information here too. So if you do need any kind of marketing help or open house help or anything at all, anything you can think of, just reach out to me. And then of course, Anita is here as well.
All right. Awesome, guys. We appreciate you guys so much coming in. You guys are wonderful.
Thank you.
And there's exciting things coming down the road with you guys. So I appreciate it. We'll talk to you all soon.
Bye, everybody.
Thank you.
All right. Any questions or comments for Florida Realty Investments, our wonderful agents? Nothing. I love it. Love you guys. You guys got your, as promised, tens of dollars were given out today, and hopefully you guys get some good coffee or whatever you get from Starbucks. They have other stuff, I guess. Jennifer's contact is in there. They did a great job for us, so I really appreciate those guys. Any questions, anything you guys want to talk about before you go? Yes, you do need a, yeah, Juliana, go ahead.
Yeah, I just have a quick question, or a situation. I have a client, he's from out of state, and I'm having a hard time explaining or making him understand that he cannot claim the house that he wants to buy here as a primary home because he already has one on the state he lives in Tennessee. But he's saying that because he's gonna live 50% of the time in Tennessee and 50% of the time here in Florida, he wants to claim it as a first-time home and request or apply for a loan.
It's 6 months in a day. So you can't do 6 months in a day in two places. That's
right.
Even in a leap year, you can only do 6 months in a day at one place.
And that's something he's gonna have to deal with the lender as well. I mean,
yeah, he's gonna tell the truth.
Because for the loan, he also wants to get the benefit of doing a lower down payment.
Well, he can say that this is going to be his primary residence. I mean, he's already got the loan in Tennessee, and you can change your mind later. You can get a primary residence here. Like I bought my home as a primary residence, but if I move to Tennessee and I'm going to move there more than half the year, I can buy a house in Tennessee and say I'm going to be there 9 months out of the year. And my loan here, they're not going to go back and change my loan here. So yeah, you can have two good primary residence loans going at once. If I'm going and have two homes that you did that way, but you can't homestead in both places.
Right. Okay.
Tax wise, you can't homestead in both places, but you can get a loan that if he swears that he intends to live here more than half the year. And those things, like she said before, the intent thing is, I mean, she has a law degree and she's a lawyer in Illinois, so she knows, but you can't enforce intent if something comes up unless somebody lied about it. In that case, she was talking about a buyer doing it for FERPTA. The buyer had nothing to gain from lying about their intent to live somewhere. So, so that's why that's why the IRS doesn't pursue that. It's not a thing, but yeah. So if he intends to live here, if he swears to an affidavit that he intends to live here, guys, you guys have all seen these people get FHA loans and stuff and lie about it. They do. And so he can lie about it. If he plans to be here 6 months in a day, and he wants to lie about it or tell the truth, whichever it is. But he can have a good loan up in Tennessee and get one with that 6 months that he intended to do it, a couple of years ago when he bought that house in Tennessee, or 15 years ago. And then, I mean, there's lots of people who do this. Lots of people come to Florida and they're going to live here. And so they say, yeah, I'm going to live here and they keep their old loan up there and rent out that house. That's perfectly legal.
Okay.
Can I just add to that?
Sure.
Thank you, Ryan. I'm a mortgage broker, and I own a mortgage company. I'm very small. The problem becomes for the mortgage broker, and the mortgage broker can actually be sanctionized. He can actually get the loan assigned to him, to his entity. So it's basically it's that loyalty, and I would let the mortgage broker know, because a lot of people try and do that, and they can go back. When you sign when you're a mortgage broker or mortgage company, you sign an agreement with a lender. I mean, there's 16, 18 pages, and it's detailed in there. And a lot of clients want to go ahead and do like an FHA to get in. They have no purpose on and not either staying there just to they just want to do it because of the down payment. It's really, they can really hurt the mortgage broker. So it falls on the mortgage broker to make sure that the client is going to do that. And you as a realtor, we have our loyalty and ethics and stuff. We have to make sure. And, we get a lot of clients, oh, how can I do that? But they don't realize that it can fall back on the actual mortgage company or the broker. And the lenders, that's why you have an 18-page document signing, and it goes everything in that. You're going to make sure that the client is telling you the truth, not because you speak the same language or the same tone or whatever, that you're going to bypass and stuff. So it does fall. So you have to look beyond your client and say, Mr. Mortgage Broker, you got to make sure that this guy's going to do that because he's intending already on doing that. And so I just, being in the industry, we have to be loyal and completely ethical.
Yeah. We're not lying to people. So
Yeah.
if he intends to be here more than 6 months in a day, then that's perfectly fine.
Yeah.
So
Absolutely. Just to know that other people can get hurt in the industry.
Well, yeah, you can't lie. Well, he can get in trouble if he's flat out lying. Yeah.
Good luck.
Go ahead, Monica. What homestead? Let's say a house that was sold in December 2024 had a homestead exemption in 2024, but it bought in LLC and it's not going to have that exemption in 2025. So when you list the house, do you put 2025 assessments are not out yet, right? So you put 2024 tax with homestead exemption. Like, what do you list? How do you put the taxes in the listing?
I would put the 2024 taxes. The 2025 won't be out till the end of the year.
So you
but it says on there tax year 2024.
And then you check the homestead exemption, right? Because
if they used homes, if the previous people had homestead exemption, so that you're showing them that was the homestead exemption rate.
Okay, cool.
But if it was somebody else's investment property, you don't do that. You're not clicking whether or not the next person could get homestead. Anybody can get homestead if it's their homestead. You're clicking whether that was the homestead rate or not.
Okay, got it.
Which people can look. They can look online, but yes.
Okay.
Any other questions? All right. Fantastic. All right, everybody. Well, thank you for coming today. We will not have open forum next week. I will be out of town. I will be in the mountains. So do not look for me on here next week at 10:30 or anytime next week. I will be able to answer your emails and stuff. You guys have questions. I'll check my email a couple times a day. Solange is in the office. She is there to help you guys. sales@flarealtyinvestments.com. And I will be back the following week. So enjoy yourselves. Have a great week. And I'll see you in 2 weeks. Bye, everybody.
Enjoy your vacations.
Thank you.
Enjoy your vacation. Yes, sir.
Thank you, guys.